Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Frank Rausan Pereira. Well, the government on Thursday sought due representation for SC and ST communities in the Supreme Court while rejecting a Collegium recommendation to elevate Uttarakhand High Court Chief Justice K.M. Joseph to the top court. In his letter to Chief Justice of India Deepak Mishra informing about the decision to return the recommendation of Justice Joseph and elevate senior advocate Indu Malhotra to the Supreme Court, Law Minister Ravi Shankar Prasad said there is no representation of the scheduled caste and scheduled tribe communities in the Supreme Court since long. As per the Constitution, there is no provision of reservation in higher judiciary, the Supreme Court and the 24 high courts. In parliamentary replies, successive governments have maintained that they had been urging the Supreme Court Collegium to give due representation to SCs, STs, minorities and women in judiciary. Justice K.G. Balakrishnan had been the only Chief Justice of India from the SC community in the recent past. On this edition of The Big Picture, we will discuss the issue of representation in the judiciary. Joining me on the program today are Siddharth, Advocate on Record, Supreme Court; Diksha Sanyal, Research Fellow, Vidhi Center for Legal Policy; Madhavi Divan, Advocate of the Supreme Court; and Henri, Tiphagne, Executive Director, People's Watch. Thank you to all my guests for joining me on this edition of The Big Picture. Diksha Sanyal, I'd like to start with you because, your organization conducted a study recently in February 2018 about representation, especially women, in the judiciary. What was your finding?
So, we primarily looked at the lower judiciary because that's one field which is not really studied that much. And data on the lower judiciary is hardly available, or it's available but it's not structured in a way that's easily accessible. So our focus of the study was primarily to look at how does gender representation look like in the lower judiciary. For the higher judiciary, we know that in the Supreme Court we've only had 7 judges now in the last 70 years, and we know that there are about just 10% of women judges in the high courts. But in the lower courts also, we see that the percentage of women judges is very low. So out of, we have only around 27% women judges in the lower judiciary, with some states such as Bihar and Jharkhand having representation as low as 13% or 11%. So this was the primary finding of our report. And what we also sought to look at was how, as you move up the ranks in the lower judiciary itself, from one position, like from the civil judge junior division to the intermediary cadre, how the percentage of women drops as you move up. And that was the primary finding that we had, that as you even move up within the ranks of the lower judiciary, the percentage of women judges keeps falling. So this was the primary finding that we had, and of course our report did not at this stage look at the reasons for this, and this is something we intend to continue to study further.
I guess we'll talk about the reasons with the other panelists, but before that, of course, Siddharth, should courts represent the broad social character in society?
Absolutely so. Why is this the case? There is a doctrine of fair representation, of fair reflection.
But there's no provision in the Constitution for this.
Absolutely so. There is no hard and fast rule per se in our constitutional mandate as such, but the doctrine is there. It has been adopted by and large by most of the countries throughout the world, that in a democratic society, the judges who decide issues which reflect or which affect almost everyone in the country must have some sort of contextual experience as to the issues they are deciding. To briefly tell you, there were 2 resolutions or declarations. One is called the Singhi Declaration and the other is called the Montreal Declaration. Both are universal declarations on independence of judiciary. Both these declarations have categorically stated that in democratic societies, judiciary ought to represent the larger ethos. It should take into consideration the different kinds of people that live in the society. In a country as huge and diverse as India, this doctrine is of utmost importance. In fact, to conclude this preliminary point, in pre-independence India, the fact that Indians were to be represented in the Judicial Committee of the Privy Council was mandated by law. So there was a law which made sure that Judicial Committee of the Privy Council is not wholly Englishmen deciding upon the Indian situation. It had provided for 2 representatives from India to be appointed in these places. So this is a long-standing principle. It has been judicially and legislatively recognized all over the world. So there is no doubt about that per se.
Sure. Madhavi, Divan, I'd like to bring you into the picture now. Is there a case for the judiciary to be free from diversity?
Free from diversity? Well, I would say, of course, that merit is absolutely paramount. We should never compromise that, and that is for 2 reasons, of course. One is that you don't want to qualitatively compromise the judiciary in any manner. And 2, I think it would be a great disservice to the particular community sought to be represented, whether it is women or whether it is scheduled caste or any other community. It would give them a bad name if there would be just tokenism in the name of the community. So I think merit is paramount. However, we must have a representative judiciary because I think that is that is what engenders public confidence in the judiciary. And we do have unwritten criteria, for example, regional representation in the Supreme Court. We have religious minority representation, although these are unwritten rules. But I think we need to expand beyond that. Today is, as you know, a historic day because it's the first time you have a woman bar appointee who has gone directly to the Supreme Court. But gender representation needs to be much, much stronger. I mean, if we have regional representation, we have, minority representation, and, why don't women count in this at all? Because, public confidence in the administration of justice is not because, if I am a woman litigant, I don't need to be before a woman judge to get justice. It's not like that. But once, the public must know that this is a representative judiciary that is in a court of say 30 or 40 judges, whatever it is, that people are well represented, and it is likely then to be more sensitive to the needs of society.
Sure.
Yeah, and also I think the fact is, 2 things, if we're talking about just the Supreme Court, I think in many ways it is the most powerful court in the world. One, of course, because of the sheer numbers, in terms of the jurisdiction that it exercises extends to, 1/6 of, humanity. And second is the sheer range and diversity of issues that they're deciding. And remember that PIL is where the court makes news, in the sense that, these are matters which affect many, many more people than are before the court actually. So it impacts livelihoods, it impacts, social human rights, it's the economy, international obligations, all sorts of things. So you need, you need to have a judiciary which is represented, and civil society must have a say, at some level in that. I think
sure,
that is
civil
important.
society must have a say, is what you're suggesting. Siddharth, why isn't there equal representation when it comes to the judiciary in this country? What are the problems really?
Okay, so somehow this question almost raises the issue that can there be reservation, right? No, it cannot be anybody's case that there has to be reservation per se, at least in the Indian sense, because Indian experience of reservation, or the Indian experiment of reservation, is attuned to services, which is not the case in judiciary, where the judges are elevated from the bar, not only it's not that they are only appointed from the lower judiciary to the higher judiciary. There are a lot of people who are elevated from the bar. So to that extent, the idea of reservation itself does not apply in the same sense that it applies to the services. But why has this not happened? Of course, is something which is ingrained in the legal, the structure of the profession, where a lot of things are sort of, it's difficult to articulate this point. But why has this not happened is, it's a clear example as to why Indian society has not been that representative in the higher echelons. And that is something which needs to be looked at.
Sure, sure. Henri Tiphagne rejoins us on a Skype link from Madurai on the program. Henri, I know you missed out on a little bit of the debate, but generally on the whole, I was asking Siddharth about why is it that we do not have equal representation in the judiciary, and is there a case for equal representation in judiciary?
Well, I think the point should be made out that this question of equal representation in Indian society in different departments, in different positions, is always that the lower castes are never represented in higher positions. So this is the general case. You take the case of diplomats, you take the case of positions in bureaucrats, the scene is the same. And therefore, the scene continues in the judiciary. However, it is sad that for the last almost 8 years, we don't have a representative of either the scheduled tribes or the scheduled caste in the Supreme Court. And this is serious. This is serious because the judges who comprise the Collegium are members of the judiciary who interpret participation, who interpret the whole question of exclusion and inclusion in society. And if these people who interpret the Constitution in the light of Article 14, 15, and 16 so intensively, it is surprising that they are not able to search and find out representatives from the scheduled caste, scheduled tribes, and women to be appointed to the Supreme Court. So this is something which deserves attention by people in position, and it is the whole caste system and casteist beliefs of people, including higher judiciary, which alone can be responsible for such gross negligence in forgetting the scheduled tribes and the scheduled castes in their representation in the judiciary.
Sure. You know, Diksha, I know your research, your study area focused on women in judiciary, but during the process of gathering the information, did you also come across information about the kind of SC, ST and OBC representation that we have in the judiciary?
No, so primarily since we focused mostly on women, we weren't looking at SC, ST and OBC representation, but a preliminary search that I have done on this topic also seems to suggest that even at the lower judiciary, the number of, say, scheduled caste judges is also not that high. It's not, I think the numbers fall significantly much more when you go to the higher judiciary in the Supreme Court and the High Courts. But even at the lower judiciary, in absolute numbers, there might be more number of judges, but that doesn't really mean, as a total percentage, that's still quite abysmally low. And so every time this entire conversation on judicial diversity gets struck when, you know, we are speaking about, okay, someone just recently got appointed. So Indu Malhotra got appointed, which is why we are talking about gender representation. But the systemic issues that even need to be, like, just simply in terms of how you need to maintain and represent data, that in itself is not available. So even to start this conversation or to begin a conversation of just how many judges are there in the lower judiciary is terribly difficult to do because we don't have access to basic amount of data. How are judges being promoted? On what basis are they being promoted? Who is deciding their promotion? So in terms of just accessing that knowledge, there is very little transparency that the judiciary, both at the higher and lower levels, maintain.
Sure. You know, Madhavi, as far as, the diversity itself or the lack of it is concerned, how does it impact victims or how does it impact litigants?
Well, not obviously and directly. However, I think, it's well known that when there's, say, a bench of 5 judges, and you have a woman or, say, someone from the scheduled caste sitting on the bench, then the bench is forced to think in a particular way, and you are then forced to be a little more sensitive than you might otherwise be about, the challenges of that section of society. So I think it does impact at least the thought process in a significant way. It definitely sensitizes it. But I don't believe that, representation of diversity should be necessarily proportionate to the population. I think we're then getting into a dangerous area of reservation. And I would again say that merit must be paramount. But we've got to try and look maybe a little harder, cast the net a little wider to see whether we can get candidates from less represented sections of society without compromising merit. And I don't believe that that can be so difficult.
Sure.
Because, if you have certain sections, like she said, that, scheduled castes or women are very, very poorly represented. But I'd say that, they're also poorly represented because they have been traditionally disadvantaged. It's so much harder for a woman or someone from a socio-economically weak background to make it up there. And naturally, the upper caste males are going to get there much before. But the point is that when you're choosing between, say, an upper caste male and a lower caste female, you've got to try and, all things being equal, you've got to look for the less represented member of society. So I think it's a question of casting the net a little wider, making the process a little more open, so that we can, it can throw up a more representative judiciary.
Okay, casting the net wider is the solution, is what you're suggesting. Yes, Siddharth.
So this is just in follow of what ma'am has said. There is a judgment called the second judge's case, which is Supreme Court Advocates on Record Association versus Union of India, where this issue was brought up with respect to merit. And it was argued whether the selection or the elevation of judges from a wide variety, a larger pool, will affect merit adversely. The leading opinion of J.S. Verma and the concurring opinion of Ratnavel Pandian both agree that merit has never been affected. If the net is wider, if judges from other communities, less represented communities, are appointed to the court. So Supreme Court at least is in agreement with the fact that merit is not an issue when it comes to appointment of members of these communities who have not been represented.
Sure.
Why this net has to be wider, and the widest in fact? I'll give you two examples. One recent Indian example is a judgment of Supreme Court with respect to educational qualifications of those people who contest elections at Panchayati level. It's called Rajbala's case. There the judges have held that there has to be a certain number of, a certain minima of educational qualification which must be met by any candidate. Had there been a woman on that bench, not to criticize the larger judgment, but on just this point, they would have known that the educational qualification for women, by and large in India, is inferior than most men. So because of this decision, more number of women have been left out from the electoral fray, because there are very few women who can have those eligibility criteria satisfied. So that is something which could have been possible had there been a lady judge or somebody who had first-hand experience of rural India. The outcome probably would have been different.
Sure.
Right? The other, to conclude it very briefly, the other example, there was a very well-known judge in the US, Hugo Black, who gave a very landmark judgment called the Miranda judgment, where guidelines were laid down that any police officer who is arresting anybody shall first read that person's civil rights out to him, that he has a right to silence, he has a right to attorney and all these things. Before that, there was no such provision that could be universally applied throughout America. In an interview, when it was asked, why did he make the process of arrest more difficult, especially in the wake of terrorism and all these things, his answer was that I had lived in rural Alabama and I had known the atrocities that are committed by police personnel while arresting black or impoverished persons. And I had seen how difficult it is for them to defend themselves. That first-hand experience translated into those Miranda guidelines years later. So the idea of justice is to feel secure in a country which is governed by rule of law. That can only be met by people who have had some sort of first-hand experience, or at least should have witnessed things, which is why it's important to have a larger net of people who can come to the courts.
Sure. Okay, let me introduce M.Afzal, Wani, Chairman, Law Department, Indraprasth University, on the program right now. Welcome, Professor. You know, what is the status of women, Dalit and SC, ST judges in the country? You know, are they not entering the legal field? Why isn't there more representation? Are they not good enough? What is the problem really?
True. Actually, we don't have a good representation of women and other marginalized sections in the judiciary. I'll be more concerned about women we need presence of women in a big way, of course on the bench, but still at the bar also we are having a lesser number of them. And at the bar we have to make comfortable things for them. They are coming now in good numbers to educational institutions, and we hope in future they will be there. But as regards the bench, we should have a good number and we should have policies for them so that they get more and more encouraged. The question is not that they cannot do the job. I believe that they can do it better, and that can create a better atmosphere, a very inclusive kind of congenial atmosphere in judiciary. And that will be representative of making really the whole of the Indian democracy very vibrant and inclusive. I believe that the authorities should look to it, and the number of the people they are available, they should be given some kind of boost, and they should be taken on the bench in a bigger way.
Sure.
In high courts, their number has to be increased, and also in Supreme Court, we should have a very balanced kind of group. And I will say here, as regards the merit in judiciary, it does not mean the the arithmetical numbers. Here is the question of mindset and understanding, social acumen, judicial acumen, and then understanding the society, behavior, how balanced it becomes. I think without an inclusive kind of group in the judiciary at any level, you cannot create that kind of very balanced mindset. So that way I believe this is very emergent. It demands that we should do much to have women and other marginalized sections which are absent from the judiciary to get them there.
Okay.
And merit should not be considered as merely that percentage of marks and other things. It is built in with reference to the social context. Because at that level everybody is having an understanding of certain norms of law, principles of law, and merit in judiciary becomes together that of the bar, members of the bar, pleading people in the court, and the brothers and sisters on the bench. It together constitutes the merit.
Okay, all
so
right.
that way we should.
Point taken. Henri, I know you've been wanting to say something for a while. I could see you putting up your hand there. Go ahead. The floor is yours.
Well, I only wanted to add that the composition of the Collegium also contributes to the exclusion of the scheduled castes, scheduled tribes, and women in the judiciary at the higher levels. However much we like to be sophisticated in our thinking, however nice we like to be generous in our thinking, it is the composition, there is a caste composition that determines matters of decision making in the Collegium. And if you have women already excluded in the Collegium, then the chances of more women being brought into elevation is almost stopped. And it is the same in terms of caste composition. If you are going to have a caste composition of people belonging to very high castes in the Collegiums, then the natural corollary is going to be that certain sections of society are going to be excluded. And I think we need to look at the composition of collegiums in order to ensure that there is inclusion and exclusion doesn't take place.
Right.
And this inclusion, if you do not want a reservation, then we should have principles. And those principles should be principles which are written down to ensure that the process of exclusion doesn't take place in the collegiums and in the manner in which collegiums take place. A collegium of this country which appeals for democracy, a collegium of this country which appeals to the people of this country to protect the judiciary, should be the very same collegium which also wants to ensure that in the Supreme Court there are women, there are larger sections of women, and there are also larger sections of representatives of scheduled castes and scheduled tribes.
Okay, all right. Your point is taken, Henri. Let me get in the other guests as well, because I've got limited time on the program to get closing comments from all my guests. One final round of comments, starting with you, Diksha, with the way forward.
So I think as a starting, what is really important is to just start documenting at a very primary level, from the lower judiciary on to the senior judiciary, just how many women judges, and judges from other communities, the scheduled caste, scheduled tribe, OBC communities are coming in, document this. So for instance, we know that UK maintains a annual diversity statistics. So India should also probably start thinking of having a statistic like that published, so that we know at the very least how this process is faring and who all, and whether, even before we can make arguments of reservation and whether they're benefiting or not benefiting, we need to have the numbers.
Okay, sure, Madhavi.
I think
What's the remedy?
Yeah, I think one is that first and foremost, we need a publicly declared process. What are the criteria? And that will help also casting the net as wide as possible, because, you know, judges have limited knowledge and it's confined essentially to, you know, good candidates within that particular court, or, you know, which may not, as I said, cast the net adequately widely. So that's definitely one aspect. Second is, I think civil society must have a little bit of a say. It was tried to be formalized under the NJSC,
right,
which got, of course, struck down in the 4th judge's case. But, you know, there, if just to remind you, there was provision for 2 eminent persons.
Sure.
They were called eminent persons. Their qualifications were not specified, and that is actually what led to the striking down, in a
right,
sense, of the NJSC.
Right.
But I think the eminent persons were important, and not necessarily from the legal fraternity.
Sure.
And that is important, because you don't want a cozy club, you know, between
right,
members of the...
Point taken.
Yeah.
Siddharth, do we need systemic change?
Absolutely so, and that is something which has been recognized world over. It is an unwritten rule that in America, the bench ought to have a Jewish person, an Afro-American, somebody from Roman Catholics. That is sort of an unstated or unwritten rule, but it's almost always practiced. And of course, a woman. Similar structural changes were brought in South Africa, post-apartheid. European Court of Human Rights also has similar processes. India has somehow lagged behind in this.
Okay.
We ought to do that now.
Okay. You know, Professor, does the Collegium system need to go if you have to see major changes?
Not necessarily. When we have the judges have to appoint the judges, I believe that they must behave like judges, and there may not be express written rules, regulations. If they go to the norms of justice and they have that conscience and compassion, I believe without those regulations and systems, they must be just, fair, and give space to all women and other marginalized sections, and make the court a very representative, so that it becomes an example for executive, for legislature, and all other institutions. And this will make, why I say it should be inclusive bench or bar, because access to justice has to be psychologically also made possible.
Indeed.
Because
Indeed.
the people must have access to different kinds of judges with different backgrounds. That will really make it just and fair and very good in the whole world.
All right. Okay. Henri, please close the show for us with your concluding remark.
Well, I agree with all that has been said, but the last point is attitudes of the judges also matters. And judges have to exhibit that they actually believe in Article 14, 15, 16 and 17. Okay. And this belief has to be expressed through their attitudes. Their attitudes are going to actually therefore determine their actions of including different sections within the judiciary. Attitude is important.
Okay, attitude is important is what you're suggesting. On that note, then we'll call it a wrap on this edition of The Big Picture. I'd like to thank all my guests for joining me on the program and putting things into perspective for us. That's it from me. See you again next time.